guest today. Yes, our principal lawyer, Len Watt. Great to have you today, Len.
Thank you, brother. It's always good to be here.
That's good. Now, before we jump on this special topic, quickly, a couple of things to the viewers who are watching this right now. If you guys have missed past episodes, jump onto our YouTube channel, Talking Legal. You can see all the past episodes we have covered up from the families to buildings, constructions, and a lot of other topics, issues right now, which is very similar to the situations currently we are in it. Now, second things, just about if you're watching this from Facebook, YouTube, Instagram, a number of channels, gives a thumbs up, comments, share it, and that will obviously help us to come up with the next topic in future. All right, so let's get into it, Len.
Yes, let's do it.
Now, a lot of viewers have asked, especially about the recent, High Court decisions, Matt and Paterson. So obviously, those viewers who are watching this right now, this is 120 years of contract law overturned by High Court of Australia. So as a trusted legal advisor, building and construction legal advisor, can you tell us a little bit about the decisions, Mann and Paterson Construction Private Limited, please?
Okay, so what we have here is a circumstance where the Manns have entered into a contract with Paterson Constructions, and they did that for the construction of 2 townhouses on their own land, and on the basis of a fixed price master builders contract for major domestic building works. At some point during the course of the construction, the parties have fallen into dispute over a number of variations, which were requested orally by the Manns, and which Paterson Constructions undertook without a basically written confirmation, which is required both by the contract and by Section 38 of the Domestic Building Contracts Act in Victoria. So both parties were, in fact, not quite complying with the contract, as both parties failed to put these particular variations or requests and then response to writing, which is required. So basically, following that, there was a request for payment from the builder to the Manns, and it was for approximately $49,000. Now, it included the stage payment that had been reached, and it included the variations that had been verbally discussed and requested. So that invoice was not paid. Then Paterson's advised, the builder then advised that they could do no further work until the invoice was paid. The Manns then claimed that Paterson was in breach of the contract in specifically clause 12 and clause 13, and that they were in breach of sections 37 and 38 of the Domestic Building Contracts Act of Victoria. So what was claimed was that the builder had repudiated the contract. Now, repudiation is an area that we could spend an entire topic on, but what repudiation means is that one of the parties wasn't ready, willing, and able to undertake their obligations in accordance with the contract. Now, that was claimed by the Manns. The builder, Paterson Construction, said no, it's an inappropriate claim of repudiation, and that itself is a repudiation which we are going to rely upon, and therefore we are now going to terminate the contract, and we have an entitlement to recover payment in VCAT in Melbourne. So in a nutshell, that's how they ended up with the commencement of the dispute.
Wow. And obviously it is quite significant, eh?
Yeah, well, the builder then has stated that they were going to look for what's called a Quantum Meruit claim.
Yeah, tell me about that. What exactly Quantum Meruit? That's
okay.
What yeah.
That's one of the main points of this case. So Quantum Meruit, it's a Latin term, and what it means is as much, well, broadly speaking, it means as much as he deserves. So it's often used in building disputes. It's basically for a claim for payment outside of the contractual entitlement for a payment to the builder. Generally, the builder will claim what they say is a fair and reasonable sum of money for services rendered and or work done. This is on the basis of the termination of the contract or it's otherwise ended. So in the cases of, say, a domestic building contract with milestone payments, the application as now determined by the High Court is that if the contract is ended between two milestone payments, so say between slab and frame stage as an example, an amount of work has been done, but the builder hasn't reached that particular milestone stage, they can make what's called a Quantum Meruit claim, which is a claim for the work that they've done up to the point that the contract has been terminated. So it's basically it's an entitlement to recover an amount of money outside the strict confines of the contract.
Okay, yep, that's pretty clear. Yeah. So what does that then? How does that relate in a particular matter, Len?
So, well, in this case, when the matter went to VCAT, the tribunal followed what was the existing position of the law, and it awarded an amount of $660,000 approximately, which was significantly more than the original contract sum. So that basically became interesting, and the matter progressed to the Supreme Court, the Court of Appeal in Victoria, and finally to the High Court. Now, each of those courts had said that they were following the existing law as it actually was at that particular point in time. I suppose in the Court of Appeal, the court said that, well, look, if there's to be a change in the law, it has to be done by the High Court. So the position of the Court of Appeal seemed to be that they were following the law, and in sort of suggesting that maybe it might be a time for a bit of a change. So the matter went to the High Court. Now, so to just build on that a little bit, the Paterson Constructions had reached a payment milestone. They were so they had an accrued right under the contract for a payment. That should have precluded them from a Quantum Meruit claim, and which only arises when there's no contractual claim or rights existing. So the proper claim by the builder was, in hindsight, a common law action to a debt recovery. For a claim for a Quantum Meruit brought by the builder, it had to be in circumstances where they hadn't reached a particular milestone. So they were claiming for unpaid work. And the other interesting thing was that the work had to be capped at the amount of the original contract price. So the court was quite specific in that they said you can't be paid a significant amount of money more than what you originally agreed to be paid when you entered into the contract.
Totally. And obviously the dispute with all the fact dispute started actually in Victoria, isn't it?
It's a Victorian dispute, but there are parts of the case that are relevant to Australia. The Quantum Meruit part of the case, as we've been discussing, has application right across the country. It is now the law in relation to these matters. So for a builder to be able to use or utilise a Quantum Meruit claim, he has to have he can't have an accrued right under the contract. So therefore, it can't be once he's reached a milestone payment and then there's a dispute about that payment. You can't then turn around and say, well, I'm going to claim a Quantum Meruit, I'm going to claim all this money. You can only seek to recover that milestone payment as a debt under common law.
Okay.
If the dispute falls between two milestone payments, then you can claim from the last time you were paid up to when you finished the work you were doing.
Right. So that you reckon that is the highlight or the lesson for the Victorian builder from this decision? Not
necessarily. In relation to the Victorian builders, it actually
yes, please.
It goes a step further and very relevant. So it deals with Section 38 of the Domestic Building Contracts Act in Victoria. Now, the takeaway is that the section basically prevents. So the High Court found that particular section of that Act prevents a builder from recovering variations using a Quantum Meruit claim. So any claim for variations can only be a claim in an action which is based in contract and not as a Quantum Meruit claim, which means that the builder must accrue a contractual right to be paid for the variations in order for them to recover the amount of the variation. So it's pointing, even though there's still a slight window, it's pointing to strict compliance with Section 38 of the Domestic Building Contracts Act. So the little window that gives the builder another opportunity is actually I think it's Section 6 of that Act from memory. But the normal operation of the Act is that if the builder believes that the variation is going to delay the project in any way, or the value of it is more than 2% of the original contract sum, therefore, hypothetically, $100,000 contract, if it's more than $2,000, that means that there must be an exchange in writing under that section for a variation to be requested and approved. And that's being upheld by the High Court. They are saying that particular section its operation continues, and the builders must comply with that section. They must request that in writing. There is an opportunity that if it's an exceptional circumstance or the builder will suffer a significant hardship, and it would not be unfair for the building owner to pay for the variations, VCAT can order recovery, but it's rare that those circumstances arise.
Right. Now, thank you, Len. That has pretty clear about the dispute raised in Victoria. So now, obviously, we have got viewers watching this from all over the states, New South Wales, South Australia, Queensland. What about that? I mean, would that affect them with this decision?
Well, as we've spoken, the Quantum Meruit part of the decision definitely has an effect on the operation of those types of disputes in all states of Australia. As to the operation in relation to variations, that's an interesting question, and I think it's one, because it's founded in legislation that's based in Victoria, that part of the actual decision is specifically grounded in Victoria. It will be interesting to see how, as we move forward, that particular part of the decision is applied elsewhere, but and we'll have to wait and see. But part of it is the Quantum Meruit part applies right across the country. The variation part under Section 38 is specific to Victoria.
Right, and I understand you are a trusted building and construction legal advisor. So if the viewers, if some of them are watching this right now and they have the issues on this, certainly you can help them. Yeah.
Of course, I think that it's very important for people fall into dispute. It's a fact of life, and in building contracts, they're very long and complex relationships, and quite often they lead to disputes. So in relation to those disputes, it's important to get some specific legal advice before the dispute escalates. And it could be that you need to talk to your legal advisor or to one of my staff about how you move from where you are now to either a contract termination or a resolution of the dispute that you're in. But it's important not just to take steps without that advice. Absolutely vital. Right.
So the initial consultation is a better, isn't it?
Oh, of course.
So, yeah. Now on that note, then what would be the best contact if someone have to contact you? What would be the best way, Len, please?
So a couple of ways. Number one is via our website. There is the ability to be able to ask for a consult through there. We have our info at beckerwatt, BECKERWATT.com.au email is another way. And our telephone call 1300 at legal is another way that people can reach us.
Beautiful. That's great, Len. Now I understand we are running out of the time. Do you have any other final say on this particular case?
Oh, look, I think that the case is it's certainly noteworthy in that it's cleared up an area of the law that was hotly debated, and that was the ability under a Quantum Meruit claim to claim more than the original value of the contract. There are a lot of legal practitioners, and I think myself probably amongst them, who felt that a claim that was far in excess of the original contract value just did not seem appropriate. And this particular decision has certainly drawn a line in the sand about that. So, a party entering into a contract needs to have some form of, a particular consumer, some form of, guarantee or assurance that the amount they have to pay is not going to increase by literally hundreds of thousands of dollars, as the case may be. So I think it's a very important part of this.
Very important. No, that's great. Thank you so much for your great insight, Len. As always, we'd love to take some of your the challenges or issues, and obviously we'll pass that to Len or the number of our trusted legal advisor on different topics or different ways. So thanks again, Len. So thanks for watching, guys. I'll see you on the next episode, same time, 5 p.m. Next week. Bye for now.